morning, everyone, and welcome to today's hearing. We are continuing our hearing from yesterday. Before we begin, pick up where we left off. I want to make sure we do our roll call of commissioners. So Commissioner Belser.
Present.
Commissioner Howard.
Here.
Commissioner Irvin.
Here.
And Commissioner Hamilton. Commissioner Hamilton, I can see you.
Here.
There we go. I heard you. Okay. Now, I believe where we are in the order is Mr. Cooper is your witness. I believe we're to Mr. Furtick. And we'll turn it over to you, Mr. Cooper, and then when we get Mr. Furtick on, we will get him sworn in.
Thank you, Mr. Chairman. This is Ashley Cooper again for Dominion Energy. Mr. Chairman, if I might, just as a clarification, since we left off yesterday, I believe you indicated this, but Mr. Xanthakos is excused, correct?
Yes, he is.
Thank you, Mr. Chairman. At this time, I'd like to call Dominion Energy Carolina's witness, Mark Furtick, to the stand.
Okay, and when we get Mr. Furtick's image up, we will get him sworn in. And everybody bear with us because we've had to have some different technical stuff going on today. So
I'm sharing my video. Is it showing up?
I can see you.
there we go. All right, we've got him now. That's good. Mr. Furtick, if you will please raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, Mr. Cooper, your witness.
Thank you, Mr. Chairman. Mr. Furtick, please state your name for the record.
Mark C. Furtick.
And by whom are you employed and in what capacity?
Dominion Energy Manager, Renewable Programs and Technical Services.
Have you prepared or caused to be prepared under your supervision direct testimony of 10 pages that was previously filed publicly and confidentially with the Commission on June 30th, 2020 in this docket?
Yes.
Have you had any changes or additions to your pre-filed direct testimony?
No.
If I ask you the same questions here today, would your answers be the same?
Yes.
There are no exhibits to your direct testimony, correct?
Correct.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Furtick be admitted into the record as if given orally from the stand, while maintaining the confidentiality of portions of Mr. Furtick's direct testimony that were pre-filed under seal in this docket.
Okay, Mr. Furtick's pre-filed direct testimony will be entered into the record as though given orally from the stand, and the confidential redactions will remain under seal.
Thank you, Mr. Chairman. Mr. Furtick, have you prepared a summary of your direct testimony?
Yes.
Would you please deliver it at this time?
I will. Good morning, Chairman Randall and members of the Public Service Commission of South Carolina. My name is Mark C. Furtick. I provided direct testimony in this docket on June 30th, 2020, and I respectfully request to provide the Commission with this summary of the same. Bridgestone America's Tower Operations, LLC, Bridgestone, is a large industrial customer of Dominion Energy that is connected to Dominion Energy's transmission system, which contains transmission assets that comprise and affect the bulk electric system. Dominion Energy supplies all of Bridgestone's retail electric power supply needs via an electric service contract. Section 3G of the terms and conditions in the service contract provides that electricity supplied by Dominion Energy shall not be electrically connected with any other source of electricity without written notice to Dominion Energy and agreement by the parties of such measures or conditions, if any, as may be required for the reliability of both systems. The terms and conditions mandate that the generating facility cannot be operated until the parties come to an agreement on the measures required to ensure that the reliability of both systems, that is, Bridgestone's and Dominion Energy's, is not affected. The parties agreed that Bridgestone must submit an interconnection request to Dominion Energy, which Dominion Energy would process in accordance with the South Carolina standard. The South Carolina standard is the agreed-upon measure to ensure reliability. Section 1.1.1 of the procedures within the South Carolina standard mandates that the South Carolina standard governs the interconnection and parallel operation of generating facilities with utility systems in South Carolina. Clearly, the Bridgestone generating plant will operate in parallel. Parallel operation is a straightforward concept which occurs when the generation is connected to the Dominion Energy system, directly or indirectly, and is operated in this connected way such that it is able to influence the Dominion Energy system, even if momentarily. In contrast, a standalone system, which may be referred to as a non-parallel system, would be considered a system that is physically and electrically isolated from the Dominion Energy system, with no possibility whatsoever of flowing power back to the Dominion Energy system, or flowing power in conjunction with the Dominion Energy system, or disturbing operation of the Dominion Energy system in any way. Additionally, the generating facility is electrically tied to equipment supplied by power from Dominion Energy. The power from the generating facility will also be used to serve the same load, which results in a confluence of the power supplied by one, Dominion Energy, and two, the generating facility. As a result, if the generating facility is placed into operation, it would need to sync or match, that is, parallel certain specified parameters like voltage and frequency of the power supplied by Dominion Energy to ensure the reliability of the Dominion Energy system and the Bridgestone plant. These challenges are heightened given the generating facility generates power using variable solar power. Lastly, at the request of Bridgestone, Dominion Energy installed a voltage sensing automatic switching scheme on the Dominion Energy transmission system to provide faster restoration of service for Bridgestone should a transmission line outage occur and additional reliability. The generating facility's possible effect on this voltage sensing automatic switching scheme must be evaluated. This is even more reason why Dominion Energy must process this request under the South Carolina standard. This concludes the summary of my direct testimony.
Thank you, Mr. Furtick. Have you also prepared or caused to be prepared under your supervision rebuttal testimony of 8 pages that was previously filed with the Commission on July 14, 2020 in this docket?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
If I ask you the same questions here today, would your answers be the same?
Yes.
There are no exhibits to your rebuttal testimony, correct?
Correct.
Mr. Chairman, at this time, I move that the pre-filed rebuttal testimony of Mark Furtick be admitted into the record as given orally from the stand.
Mr. Furtick's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Furtick, have you prepared a summary of your rebuttal testimony?
Yes.
Please deliver it at this time.
In my rebuttal testimony, I note that Dominion Energy has processed thousands of requests under the South Carolina standard, residential customers utilizing rooftop solar and industrial behind-the-meter generation. In fact, I cannot think of a situation where any such generation that is not standby generation only would be placed into service on the Dominion Energy system without first following the South Carolina standard. As such, even small projects like rooftop solar, which involve behind-the-meter generation that is meant to flow power in conjunction with Dominion Energy to the same premises, precisely the operating posture of the generating facility, are set up to South Carolina standard. I also respond to Mr. McGavran's testimony referring to actual past events at other Bridgestone facilities as a reason why the Bridgestone generating facility should not be processed under the South Carolina standard. The South Carolina standard does not permit Dominion Energy to allow a generator to operate in parallel without any review based upon the load service provided to another part of the Dominion Energy system. The South Carolina standard requires Dominion Energy to review each generator, terms and conditions of the South Carolina standard, and the effects such generator would have on the Dominion Energy system prior to. If the South Carolina standard mandated, as Mr. McGavran advocates, that projects could bypass the study and review process so long as Dominion Energy had another project with similar characteristics on the system already, This would mean that thousands upon thousands of rooftop solar customers would be exempt from the South Carolina standard entirely, given that one rooftop solar customer went through the South Carolina standard and was placed on the Dominion energy system. Such a result would not be in accordance with the rules and policies adopted by this commission. Finally, I explained that Dominion Energy often gets questions from developers related to the queue process and receives requests to exempt certain projects from various requirements of the South Carolina standard. Although I understand that each generator may look at their project in isolation and believe that an exception for a project when compared to the entire Dominion Energy system would be appropriate, Dominion Energy is tasked with maintaining the entire Dominion Energy system and following this commission's rules. If the Bridgestone generating facility were not subject to the South Carolina standard, it would provide a path forward in the future for numerous generators of any size to interconnect and operate in parallel with Dominion Energy while bypassing, one, the commission, two, the study and review process Dominion Energy is required to take to ensure the Dominion Energy system can continue to operate safely and reliably upon interconnection. This concludes the summary of my rebuttal.
Thank you, Mr. Furtick. Mr. Chairman, Mr. Furtick is available for cross-examination by other parties and questioning by the commission.
Thank you. Okay, for cross-examination, first, Ms. Lee from Coastal Conservation League.
No questions. Thank you, Chairman.
Thank you. Mr. Knowles from ORS.
No questions. Thank you, Mr. Chairman.
Thank you. Thank you. Mr. Elliott.
Yes, sir, Mr. Chairman, if I may. Mr. Furtick, can you and I agree that the issue before the commission is a novel issue?
No, I would not agree with that.
All right. Well, if you'll permit me to draw your attention to your pre-filed direct testimony at page 5, lines 16 through 18. Please tell me when you're there.
My direct.
Yes, sir. Page 5.
Yes, I'm there. I'm sorry.
All right. And isn't it true that you testify at lines 16 through 18 as follows? As an initial matter, let me point out that, to my knowledge, this is the first time that a generator seeking interconnection with DESC has claimed will not operate in parallel with the DESC system. Have I correctly quoted your pre-filed direct testimony?
That's correct.
All right, and you and I can agree, Mr. Furtick, can we not, that there's always a first time for everything?
I suppose so.
Yes, sir, and I would ask you, sir, isn't it true that your concern and Dominion's concern is that if Beto's solar array is not deemed as operating in parallel by this commission, then it is unclear how many, if any, generators in South Carolina would be subject to the South Carolina standard, given that they contain similar, if not identical, operating characteristics. Have I correctly described your testimony, please, sir?
That portion of my testimony typically says that, to my knowledge, this is the first time a generator seeking interconnection with DESC has claimed it will not operate in parallel with the DESC system.
Well, I'm sorry. I have moved on. May I draw your attention, please, to page 8 of your pre-filed direct testimony, lines 7 through 10?
That's correct. There.
So I've correctly described yours and Dominion's concern, have I not?
Yes.
Now, I would like to understand a little bit before we proceed about, just briefly, about the Dominion, corporate structure here. So you are, your title is Manager of, help me out.
Renewable Programs and Technical Services.
Renewable Programs and Technical Services. Now, does Mr. Xanthakos work in your division?
He does not.
And what division is he in?
Transmission, I believe, is the organization he is under.
All right, so he's in transmission. And how about Matt Hammond? Does he work in your division?
He does not.
What division does he work in?
He works in transmission as well.
So Mr. Hammond works with Mr. Xanthakos.
That's correct.
And how about Stephen Scott Bell? Does he work in your division?
He does not.
And where does he work, sir?
He works in the transmission organization as well, I believe.
All right, sir. And then Jess Ballantyne was formerly with your company. I think he's retired. What division did Mr. Ballantyne work in?
Customer relations.
All right. And then last, Daniel F. Cassis. Do you know Mr. Cassis?
Yes, Mr. Cassis is my immediate supervisor.
All right. And so you work for Mr. Cassis, and is his title still Vice President, Customer Relations and Renewables?
I believe it is.
All right. And do you feel like you work closely with Mr. Cassis?
Yes.
Mr. Chairman, I've got an exhibit I would like to produce to the witness, and my secretary will email it now to all parties. It is in my packet, Madam Court Reporter.
Okay, give us a little second here so we can get this all up.
And I'm getting Miss Week the number.
Okay.
It's number 6, Beto 6, Ms. Wheat. It is a one-page document. It's an email.
Okay, we're closing in on it.
Yes, sir. Thank you. Now, Mr. Furtick, I showed
Okay,
you
hang on
email.
1 second. 1 second, Mr.
Thank-
Elliott. We want to make sure we got everybody. Are we good here? This, okay. All right, proceed.
I need to refer to counsel. We've emailed it to Mr. Cooper, all counsel, but we've emailed it. If without objection, I'll proceed.
Okay.
Mr. Furtick, do you see before you an email from Cassis Dan F? Do you see that email?
I do.
And Mr. Cassis is your supervisor, if you will, correct?
That's correct.
And you are aware that Mr. Cassis has been working on this Bridgestone solar array project for at least a couple of years, if not longer, correct?
Correct.
And you know, for no other reason, through yesterday's testimony and the pre-filed testimony that you have no doubt reviewed prior to your testimony this morning, that Derek Freeman is Bridgestone's electrical engineer at the plant site, correct?
Correct.
And if you know Mr. Cassis as well as I do, if not better, you know that Mr. Cassis is very attentive to Dominion's customers. Would that be a fair characterization of Mr. Cassis?
Sure.
All right. Now, you will see from the email that Mr. Cassis writes Derek Freeman and informs him as follows. Derek, I'm still working to find a way to address the interconnection issue. However, as we both noted, finding a workable solution is complicated because any solution must not discriminate against other parties that want to interconnect to our system. Bridgestone has the right to build the asset, but the interconnection of the asset is prohibited until we can reach a resolution that our regulators will approve and that will not discriminate against other solar projects. Have I read Mr. Cassis's email correctly?
You have.
And like you have testified, Mr. Cassis expresses in this email a concern that Dominion not discriminate, correct?
Correct.
But you will note that Mr. Cassis has informed Bridgestone that it has the right to build the asset but cannot interconnect it, correct?
That's correct.
And so, Mr. Furtick, we're at a point where Bridgestone has built the asset but has not interconnected it. Isn't that true?
I believe it is. I have not verified that. I haven't seen it, but that's just what I understand.
All right, and you understand that because if not for no other reason, you've talked with Matt Hammond about this matter, correct?
I've been involved with conversations regarding this project, yes.
All right, so you don't dispute that it's not been interconnected. Now, if you would, excuse me, go ahead. I didn't mean to cut you off.
I said that's correct.
All right. Now, I would like, I can't tell who's at the Elmo, but if I can impose on her to scroll down to the email from Mr. Freeman. All right. Do you see that, Mr. Furtick?
I do see it.
Excellent. Thank you. It is correct that it is an email from Derek Freeman to your supervisor, Daniel F. Cassis, correct?
It appears to be.
And in that email, Mr. Freeman informs Mr. Cassis as follows. We at Bridgestone are quickly coming up on end-of-year time limits where we need to make financial decisions for capital spending because we budget capital for upcoming years. If the project is scheduled to be completed in 2018 but rolls over into 2019, then the projects will have to be canceled or delayed to make room for the 2018 carryover. If we know in time and can move a 2019 project up, then we can offset carryover by doing the 2019 scheduled project early. The larger the project, actual dollars, to be carried over, then the sooner we need to know in order to have time to offset it. Is there any movement on the decision to let Bridgestone continue with the installation but not activate the solar field project? We have several hundred thousand already spent, and we still have several hundred thousand still budgeted to spend in 2018. Thanks for your help. Have I correctly read Mr. Freeman's email?
I believe you have.
All right, and so to put Mr. Cassis's email in just a little better perspective, Mr. Cassis responds, I'm still working to find a way to address the interconnection issue, doesn't he?
I can't see the top part now, but I believe it does.
All right, good. Mr. Chairman, I would move the Cassis and Freeman email exchange into the record as the next hearing exhibit.
Okay, they will be hearing, excuse me, they will be entered as hearing exhibit number 9.
Thank you, Mr. Chairman, and thank you, Mr. Furtick.
Welcome.
Now, I'd like to draw your attention, if I may, to the contract between Dominion and Bridgestone. Sir, you are aware that Dominion and Bridgestone operate under the terms of a contract approved by this commission, don't you?
I do. Mr. Elliott, could you maybe get a little closer to the mic? I've turned my volume up, but I'm still struggling to hear you just a little bit.
It's not my intention. Is that any better?
Yes, it is. Thank you.
All right, thank you. And in fact, in your direct testimony, and I'll help you here.
Hang
on
on
page
one
3.
second, Mr. Elliott. We had our screen go down. Who was asking, was the witness asking that last question? For
Yes,
him
sir.
to turn up his volume? Who was asking about the volume?
I understood that to be Mr. Freeman.
Okay, Mr. Freeman. Okay,
Furtick.
we're just getting that right for the court report. Mr. Furtick, Mr. Furtick.
Sorry, this is Ashley Cooper. I just wanted to clarify, it's not Mr. Freeman. That would be Bridgestone's witness. This is Mr.
I understand,
Furtick.
yeah, we missed, my mouth didn't work right. It's Furtick. Sorry, thank you.
Mr. Furtick, I apologize. I have great admiration for Mr. Freeman. I'm sure I meant that as a compliment.
I have great admiration for him as well.
Thank you. All right. Now, if I may, I was drawing your attention to page 3 of your pre-filed direct testimony at the bottom of the page, or at least lines 19 through 23.
Okay, I'm there.
All right. And here you are quoting the provisions of section Roman numeral 3, capital G, of the terms and conditions of that contract, are you not?
I am.
And can we agree that that provision of the contract reads as follows: electricity supplied by desk shall not be electrically connected with any other source of electricity without reasonable written notice to desk and agreement by the part of such measures or conditions, if any, as may be required for reliability of both systems. Have I quoted your testimony correctly?
You have.
And can we agree that that's a verbatim quote from the Dominion and Bridgestone contract?
I believe it is.
All right. And so from our review of Mr. Cassis's email to Mr. Freeman, we are informed that that Dominion informed Bridgestone that it may construct the solar array but may not interconnect it. Isn't that true?
I believe that's what it said, yes.
And as a practical matter, Mr. Freeman was informing Mr. Cassis of the reasons for Bridgestone's request to construct the solar array, and Mr. Cassis, by virtue of his email, seemed to understand Mr. Freeman's request. Would you agree?
I can't speak to what Mr. Cassis understood. I believe he was stipulating that we couldn't stop the construction; it would be at their risk, but that we did have to work out the issues of the interconnection. And
Mr. Cass's email and Mr. Freeman's email comply completely with the provisions of the contract that you quoted here at the bottom of page 3 of your pre-file direct, correct?
Mr. Chairman, this is Ashley Cooper, counsel for Dominion Energy.
Yes, sir.
We object to the extent this calls for a legal conclusion about compliance with the contract.
Okay, we're going to sustain that.
Thank you. Mr. Furtick, do I understand that you've never been to the Bridgestone facility, correctly?
That's correct.
But I do understand that you were present in the hearing yesterday for Mr. Xanthakos' testimony. Is that correct?
That is correct.
And as a part of your preparation, which I'm sure was extensive for your testimony in this morning's hearing, you reviewed Mr. Xanthakos' testimony, did you not?
Briefly, yes.
All right, sir. And you will recall that attached to Mr. Xanthakos' testimony was a schematic diagram or drawing that he was questioned about. Do you recall that?
I do.
I'd like to draw your attention to that schematic diagram for a moment, if I may. And Madam Court Reporter, this is Exhibit 1 to Mr. Xanthakos' surrebuttal testimony. It is a chart, what purports to be an electrical chart with some black and red coloring. I'd like to show that to the witness, if I may.
We're getting that together right now.
Thank you very
Mr.
much.
Elliott, was that part of Exhibit 7, hearing Exhibit 7? That'll be better.
Let's review my notes. I think so, yes, Ms. Wheat. It would be, yes, it would be, and it would be the first exhibit, one page.
Thank you.
It was originally marked confidential, but it has been deemed not confidential. Just want to
Correct,
make sure
Chairman.
that's, everybody's on the same page there. Yes, yes, we may show it.
Yes.
Okay. Go ahead. I think we're ready.
Thank you. Could you bring it down a little bit, Madam Court Reporter? It's not legible at the top, I'm afraid. I thought we had a pretty good view of it yesterday when we were examining the witness.
You must have had a different view than I did then, because I couldn't see it yesterday. It looks about the same as it did yesterday. We're working on it.
All right, I'm looking at my file copy that I printed off my computer. Mr.
How about that? Is that a little better?
Excuse me.
Yes, in fact, if you just bring it down a little bit more, I'm more interested at the diagramming at the top than the bottom. Not there. Bring it on down to that larger red circle towards the top. It might show a little better if you bring it down. No, not that one at the top. No, can you bring it down farther? I just want to show him the very top line.
Hey, Mr. Elliott, this is Jocelyn Boyd. So tell me if I'm going in the right direction, please.
You're going in the correct direction.
All right, bring it down a little more.
Yes, ma'am. I'm hoping that perhaps if you do, it's more legible, but maybe not.
All right, I'll zoom in a little bit more if you'd like.
Yes, try. All right, let's just stop there. Mr. Furtick, after all that, this may go very quickly. Mr. Furtick, you've had a chance to review Mr. Xanthakos' diagram prior to your testimony this morning, have you not?
Again, very briefly.
Yes, sir. And you are an engineer, although mechanical, not electric, but you're an engineer, are you not?
That's correct.
And you understood from your review of Mr. Xanthakos' chart that the line at the very top of his chart represents the Dominion 115 kV overhead service lines. Do you not?
Yeah, I'm struggling to see the drawing on the screen, but I believe that to be correct.
All right, and would you have a copy of Mr. Xanthakos' testimony in your possession?
Not handy. I could find it if you want to give me a minute.
I would like to give you a minute. Once we get this, once you're able to look at this, I think it will go very, very quickly.
Okay, hold on.
And Mr. Furtick, if I may, I have the highest regard for mechanical engineers. My father and father-in-law were mechanical engineers, so I don't mean to suggest that your degree is any less relevant to our review this morning.
Understand, appreciate that. And I have the drawing up now.
All right, so if you look at the very top line, it represents the 115 kV overhead primary service lines, does it not?
Yes.
And could you tell me here from this drawing where we would expect to find Dominion's meter to the plant?
Somewhere where the green is highlighted or the purple, one of those two locations likely.
All right, I'm looking at red and black. So there's a on mine there's oval.
Mr. Chairman, this is actually Cooper. I'm not objecting, but I want to seek clarification. I feel that it seems like they might be looking at two different exhibits.
Okay, well, hang on,
Actually, we may be. I am looking at my file copy, which now that Mr. Cooper brings to my attention may not be the copy that was on the screen.
May I ask a question?
yes, Commissioner Belzer.
Mr. Cooper, this is the diagram that I asked to be highlighted. Perhaps is the copy that the witness is looking at, is the highlighting already been done? This is the one I asked for the late filed exhibit?
Yeah. I'm not with Mr. Furtick, but I don't know if he's not looking at maybe an internal document and not the document that Mr. Elliott has.
Thank you.
Yeah, perhaps I am looking at the wrong document. If somebody could send it to me.
Let's see. Let me hang on. Give me 1 second. Let me talk with my colleagues, see if we can email it, or if Mr. Elliott has it handy. If you want,
Okay.
we can get it to Mr. Furtick.
Mr. Chairman,
I could email.
this is when we can email to all the parties a copy of hearing exhibit 7, if that will help, and then Mr. Cooper can email it to his witness.
Will that work? Will that help?
Mr. Chairman, if that question is to me, yes, that would work. I would
Okay.
ask Ms. Weed, if you don't mind, would you mind copying Mr. I guess either Mr. Burgess or Mr. Gissendaner, just in case there have been some connection issues, and so I just would like to have one other person on this just in case.
Mr. Cooper, this is Joanne Wessinger Hill. We will email it to everyone that we've emailed it before, not just you, Mr. Gissendaner, everybody.
Thank you very much. I appreciate the clarification.
You're welcome.
I appreciate your indulging me, Mr. Chairman.
Well, we want to get it all right, so we're working on that right now, and I will let you know when I get the thumbs up.
Yes, sir. Thank you. And Mr. Chairman, if I may address Ms. Wessinger Hill.
Go ahead. She's working on sending that thing, so.
All right, when she's through, it was kind of a pre-hearing matter that she and I, actually, it was a matter that she and I were working on.
Okay, we'll hold that thought.
Excuse me, Mr. Chairman, I'm stepping away.
The email has been sent with hearing exhibit number 7, so everyone should be receiving it shortly. Please check your email boxes.
And, Mr. Chairman, I do not need to impose on Ms. Wessinger Hill. My secretary's resolved the problem I was going to raise with her, so thank you.
Okay, thank you.
That's one of the many advantages from being able to do this from your office.
Okay, everybody let me know when you have received that so that we can move on.
Mr. Chairman, this is Ashley Cooper for Dominion Energy. We've received the email in both. I have forwarded it to Mr. Furtick as well as my colleague Will Middleton. So, Mr. Furtick, you should be receiving this from, I suspect, probably several people. You probably got it from Mr. Gissendam or Mr. Burgess as well.
And we'll wait for Mr. Furtick to get that, and I guess then we'll be able to move ahead, correct?
Yes, sir, Mr. Chairman. I've received the email, and it's a document I've been attempting to examine the witness about.
Okay, Mr. Furtick, do you have it?
I do not. I'm looking at my inbox now.
Mr. Chairman, this is Ashley Cooper for Dominion. I just got a message that Mr. Gissendam nor Mr. Burgess have received it yet. So it may be a little bit slow email communication. We'll let you know as soon as they receive it.
Okay, thank you.
Mr. Chairman, this is Ashley Cooper for Dominion Energy.
Yes, sir.
I just going through you, Mr. Chairman, to communicate to the witness and
Certainly.
Mr. Elliott at the same time. I think we've now sent it, and Mr. Burgess has sent it to Mr. Furtick. So hopefully, if he's checking his screen, his emails, hopefully we'll see something soon.
Okay, thank you.
Okay, I just got it.
Okay. You let us know, Mr. Furtick, when you can have it opened up and see it, and then we'll be able to proceed.
Okay, I have it, and apologies for confusing the issue by opening the wrong drawing.
No problem. I think we've got a little cleaner document up on the screen now as well.
Okay.
Okay, Mr. Elliott, I think it's back to you.
All right, very fine. Thank you, everyone, for accommodating me. Mr. Furtick, I think you should be looking at a one-page document that's similar to that which is on our screen at this moment. Are you not? Well,
I am. It's marked Exhibit 7, dated 7/28/20.
that would be right, I believe. And so, again, just to get our bearings, there is a line at the top of the diagram, and it represents, according to the diagram, the 115 kV overhead primary service lines. Is that correct?
I believe it does.
All right, sir. And my question to you at the time we broke to get better copies for you was, can you tell me where on this diagram Dominion would have placed its meter?
It's not showing on the diagram, but I would assume it would be underneath the transformer, near the area that's in the box that says PCS or something like that. I can't quite read it. Somewhere in that general vicinity before Bridgestone's breaker.
All right, before Bridgestone's breaker, would it be above the the page-wide dotted line, or above it, in your opinion?
I'm not sure. It's probably immediately near it, I would say.
All right, sir. And the meter would belong to Dominion, correct?
That is correct.
Because Dominion needs to ensure itself that the meter is in accurate working condition, correct?
Correct.
Now, are you familiar with the terms point of interconnection or point of common coupling?
I am.
Would it be fair to say the point of interconnection or point of common coupling between the PV system, the photovoltaic system, and the utility is through dedicated electrical switchgear, substation, switchyard, or similar methods whose sole purpose is to safely and effectively interconnect the two systems? Would that be a fair statement in your view?
Could you repeat that and maybe give me the reference of that?
Mr. Chairman, this is Ashley Cooper, counsel for Dominion.
Yes, sir.
I just have a very limited objection. I object to the form of the question, that it's not clear what the question is asking, because he's thrown out multiple things that could constitute a interconnection.
Well, I asked the witness, Mr.
Well,
Chairman.
yeah, just rephrase that and get it a little cleaner there, Mr. Elliott.
Happy to, sir. Mr. Furtick, I simply want to read you a definition of or at least an explanation, a brief explanation of the terms point of interconnection or point of common coupling, and ask you if you agree with it. And I'll read it. The point of interconnection or point of common coupling between the PV, which stands for photovoltaic system, and the utility is through dedicated electrical switchgear, substation, switchyard, or similar methods whose sole purpose is to safely and effectively interconnect the two systems. Do you subscribe to that description of point of interconnection and point of common coupling?
And Mr. Chairman, this is Ashley Cooper with Dominion Energy. It may be helpful for Mr. Elliott, since he's reading a definition, to clarify, are these IEEE standards you're reading? I don't know that you've provided us where you got this definition, just to help the witness understand.
Mr. Chairman, I don't know that I need to provide the witness a citation or any...
Okay, The
And
witness
what-
can answer if he knows the answer, the witness can answer. If he doesn't, don't.
Yeah, I can't really answer that without reviewing the whole context of what you're reading from. I mean, to me, the interconnection is a portion of the system, be it Bato's and or ours.
All right, thank you. Would you be able, Mr. Furtick, to demonstrate to us or point to us where on Mr. Xanthakos's diagram, hearing Exhibit 7, where Dominion's property stops and Bridgestone's property starts?
I believe it would be the dashed line going horizontally across the page.
Thank you, Mr. Furtick. You've been very helpful. No further questions, Mr. Chairman.
Thank you. Okay, commissioners, questions? Commissioner Belser?
Thank you, Mr. Chairman. Good morning, Mr. Furtick.
Good morning, Commissioner.
Thank you for your testimony this morning. Are you aware of any other generators who are that are proposing to interconnect with Dominion's system, where those generators are proposing to use 100% of the output from their renewable or solar array?
Yes, I believe there are several that would operate in that mode.
And where are they in the queue?
I can't answer that specifically. I believe there's an already interconnected, and then there's at least one more, I believe, that's in the queue.
And how long is it taking Dominion to perform the studies required under the South Carolina GIP? If I were to, if my number came up today, I was looking to do some sort of project, and my number came up today, how long is it going to take Dominion to perform the studies?
Commissioner, I'm assuming you're speaking to the study process specifically. There's three parts to the South Carolina standard, and I can't specifically address that because that's not my specific area.
Okay.
I believe another witness coming behind me would be better able to answer that.
And who would that be, please?
Witness Hammond.
Thank you very much. That's all I have, Mr. Chairman.
Thank you. Commissioners, any other questions?
Mr. Chairman, Commissioner Howard.
Commissioner Howard.
Mr. Furtick, if the commission does waiver the South Carolina JIT procedures, is the name of JIT to performing a faith and reliability test with its solar array?
We would not. We would request to be able to complete the study and then perform any testing that we're required to put the array in service. We do feel it's...
Go ahead, I'm sorry.
Go ahead, I'm sorry.
No, you go ahead, I'm sorry.
I'll just say we feel it's very crucial that the study be performed before it's put in service.
Do the terms and conditions of the service contract between y'all now establish sufficient guidelines to conduct such a test?
We feel the terms and conditions don't exempt any project from other commission regulations like the South Carolina standard. But if you granted it a waiver, then we would use the terms and conditions as a path to do the study, yes.
Okay, well, I'll ask you this question also. If the solar array becomes operational, what is the anticipated loss to Dominion in kilowatt-hour sales?
I don't have that number in front of me. I could get it and get back to you, though, Commissioner.
Thank you very much. I'd appreciate that. Mr. Chairman, that completes my questions.
Thank you. Commissioner Howard, do you want a late filed exhibit on that?
Yes, sir, I would.
Okay. If we can get a late filed exhibit on Commissioner question, we will,
Mr. Chairman, if witness that follows him have that information, I would need a late file exhibit.
we don't know if that's, what do you, Mr. Furtick, you may have to comment on that.
Yeah, I might defer to Mr. Cooper, but I would think we could possibly do it.
Safest way would be to do a late file exhibit, I think, so.
Okay.
Okay, and it can be withdrawn if somebody else can answer that question, but we will assign hearing exhibit number 10.
Thank you, Mr. Chairman.
Thank you. Okay, commissioners, any other questions?
Mr. Chairman.
Commissioner Irvin.
Thank you. Mr. Furtick, how are you this morning?
I'm good. About you, Commissioner?
Fine, sir. I understand that the North Carolina Commission has asked the stakeholders in North Carolina to try and they've been meeting regularly in a working group to try and reduce the wait time for people in the queue. Are you familiar with that?
I am.
And have you been involved in it directly?
I have been able to listen in on a few of the calls. I'm obviously not a direct participant because I'm not in North Carolina, but I have been able to listen to some of that.
One of the concerns that I have is the long wait in the queues, and my understanding is that North Carolina, the stakeholders have met and proposed a regional type approach where you can move the queue along. Are you familiar with that concept?
I am.
And is it possible that we could ask the stakeholders in South Carolina to do a similar workup? Because it's really not to anyone's benefit to have these two-plus year waits to get to the application. Would you agree?
I would agree with that, Commissioner. And I'll just add too that early on, when there was not a lot of projects, these type of projects would flow through fairly quickly. But just due to the way the standard is designed, it allows speculative type positions and people to sit there a long time without making any decision, and in turn holding up everybody behind them. So I know that's another piece they have looked at in North Carolina. So
yes, sir.
Definitely think it's something we should consider.
That's certainly a problem, and I would greatly appreciate it if you could convene the stakeholder meeting with the assistance of our ORS and see if we can get a similar agreement. We don't have to reinvent the wheel, but since North Carolina's looks like they're about a year plus ahead of us in terms of this type of simplification, it would seem to serve everyone's best interest. Would you agree?
I would agree, and we can certainly do that. I believe there's already a docket that this commission has opened. And I will add, too, though, that the standard has not blocked solar, certainly in South Carolina. We have connected a tremendous amount of solar using the standard, and it has worked pretty well. But there are some issues that do need to be looked at and possibly reformed.
Thank you very much. I appreciate your willingness to look and consider that. And I think that, you all have done a good job with applying the standard. It's not Dominion's fault necessarily. I think you've already called our attention that there are people in the queue that maybe have abused the process, and there's a better way to do it, and I think North Carolina's on to something. So if you could, if you promise to follow up with that, that would be great for South Carolina. I appreciate that very much. No further questions.
Thank you.
I
Commissioner.
intend to, and I appreciate your comment. I'm sorry.
That's okay. Commissioners, any other questions? Okay, any redirect, Mr. Cooper?
Thank you, Mr. Chairman. I'll be brief. If you could just give me one moment to look at my notes, because a couple of things he was able to answer. I do want to ask just a couple of questions of Mr. Furtick, just so it's clear. Mr. Furtick, you were asked a question about waiving the standard and being allowed to expedite a study. I just, and you noted that that would be one option. Let me ask you another option along those same lines. Could the commission, let's assume we apply the standard, Mr. Furtick. So let's just assume, I want to ask you two different scenarios, assuming we apply the interconnection standard. If we applied the interconnection standard, but we wanted to expedite or grant, or Dominion Energy wanted to grant a waiver to expedite or give some advantageous treatment to Bridgestone, may Dominion Energy on its own grant such a waiver?
Mr. Cooper, the way I read the standard, we could not do that.
Okay. But if we wanted to still apply the standard and have this project studied for safety and reliability, could the commission grant a waiver while still applying the standard that may allow for some sort of expedited treatment or review? Is that correct?
I would agree with that statement, yes.
Okay. So that's just an additional option to the other option that was identified. It's not in conflict. One other question for you, Mr. Furtick. And Mr. Chairman, I would ask if, for some assistance, I don't know whether I should direct this to Ms. Wessinger or Ms. Wheat, but the email that was referred to in the cross-examination by Daniel F. Cassis to Derek Freeman, if that could be placed back up on the Elmo.
Okay, we're gonna get that. Okay. Can everybody see that? Not yet? Okay.
I can see it.
Okay. Mr. Furtick, I'm going to read.
Just lost it. Yeah, okay, back.
Perfect. All right. Mr. Furtick, I'm in the section of Mr. Cassis, his response to Mr. Derrick. And I direct your attention to the last sentence. And the last sentence reads, Bridgestone has the right to build the asset, but the interconnection of the asset is prohibited until we can reach a resolution that our regulators will approve and that will not discriminate against other solar projects. Do you see that, Mr. Furtick?
I do.
Okay. By Bridgestone's estimate, they spent almost $3 million on this project. Would you consider it giving a project, quote, the green light if they were told the interconnection is prohibited?
I would not.
Okay. Thank you, Mr. Furtick. I appreciate it. Mr. Chairman, at this time, I have no further questions for Mr. Furtick.
Thank you. Any recross on those questions?
Oh, thank you, Mr. Chairman.
Okay.
Mr.
All right.
Chairman, I ask that Mr. Furtick be excused.
Okay. Yeah, we're trying to make sure we get back on the screen. Mr. Furtick, we appreciate you being here. We appreciate your testimony. You may step down and be excused. Thank you.
Thank you.
Okay, Mr. Cooper.
Okay. Mr. Chairman, hopefully we're going to get some momentum here. I'm going to call Mr. Joseph L. Hodges to the stand, please.
As soon as we get him on the screen, we'll swear him in and continue. All right.
Okay, I'm here.
All right, Mr. Hodges, if you will raise your right hand, please, sir. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Okay, Mr. Cooper?
Mr. Hodges, please state your name for the record.
Joseph L. Hodges, Jr. I go by Joe.
Thank you, Mr. Hodges. And by whom are you employed and in what capacity?
Dominion Energy South Carolina, Inc. I am manager of renewable programs and technical services.
Have you prepared or caused to be prepared under your supervision direct testimony of 5 pages that was previously filed publicly and confidentially with the Commission on June 30th in this docket?
I have.
Do you have any changes or additions to your pre-filed direct testimony?
No.
If I asked you the same questions here today, would your answers be the same?
Yes.
There are no exhibits to your direct testimony, correct?
No.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Hodges be admitted into the record as if given orally from the stand, while maintaining the confidentiality of the portions of Mr. Hodges' direct testimony that were pre-filed under seal in this docket.
Okay, Mr. Hodges' pre-filed direct testimony will be entered into the record as though given orally from the stand, with the confidential redactions remaining under seal.
Thank you, Mr. Chairman. Mr. Hodges, have you prepared a summary of your direct testimony?
Yes.
Would you please deliver it at this time?
Yes. Good morning, Chairman Randall and members of the Public Service Commission of South Carolina, the Commission. My name is Joe Hodges. I provided direct testimony in this docket on June 30th, 2020, and I respectfully request to provide to the Commission with this summary of the same. The testimony submitted in this docket by Bridgestone America's Tire Operation LLC, Bridgestone, indicates that Bridgestone's corporate sustainability goals motivated, at least in part, Bridgestone's desire to operate the solar generating facility that is the subject of this dispute. Dominion Energy is uniquely positioned to help Bridgestone achieve such goals while Dominion Energy processes the generating facility's interconnection application, given that Dominion Energy maintains contractual rights to renewable energy certificates, RECs, associated with approximately 2 megawatts of solar generation on the Dominion Energy distribution and transmission systems. Dominion Energy manages these RECs through its account with the North American Renewable Registry, NAR. Through NAR, Dominion Energy is able to transfer and retire RECs on behalf of itself or other entities. This means that Bridgestone can either purchase RECs from Dominion Energy or have Dominion Energy retire such RECs on Bridgestone's behalf in order to help Bridgestone achieve its sustainability goals. Dominion Energy's current REC inventory and projections for future inventory indicate that Dominion Energy would be able to provide Bridgestone with enough RECs to cover not only the amount of load that would be offset by the generating facility for 2019 and 2020, but also offset even more for Bridgestone's load. Lastly, it is important to note that the proceeds obtained through Dominion Energy's sale of RECs do not directly benefit Dominion Energy's bottom line, but instead are used to lower purchase power costs. This means that Dominion Energy's REC sales directly benefit Dominion Energy's customers. This concludes the summary of my direct testimony, the summary of my direct testimony, and I would like to thank the Commission for hearing my summary.
Thank you, Mr. Hodges. Mr. Chairman, Mr. Hodges is available for cross-examination by the parties and questioning by the Commission.
Okay, thank you. Okay, Ms. Lee.
No questions here, thank you.
Thank you. Mr. Knowles.
No questions. Thank you, Mr. Chairman.
Thank you. Mr. Elliott.
No questions. Thank you, Mr. Chairman.
Thank you, Mr. Elliott. Commissioner, any questions? Commissioner Belser.
Good morning, Mr. Hodges. How are you?
Good morning. Good. How are you?
I'm fine, thank you. We are here discussing whether or not the solar array, the interconnection of that. I really am just kind of curious why Dominion is bringing up these recs like this. I mean, are you saying that this is an alternative to building the solar?
No, ma'am. So it is a great question. So it was described in the direct testimony of Ms. Cannon that part of the reason that they had installed this or were installing this solar farm was because of their sustainability objectives. So the thought being is that in the interim, until we can properly study this facility, this solar facility, to make sure that it is going to interconnect safely and reliably, this would be one method of which we could subsidize any type of environmental advantages or anything that would contribute to their sustainability efforts or programs during that period, ma'am.
Okay.
Does that answer your question?
That does. Thank you. And can you give me a ballpark on how much a rec cost?
So Mr. Chairman, this is Ashley Cooper, counsel for Dominion. And please understand, I'd like a complete answer given to the commissioner's question. I just asked a procedural question. To the extent that these are negotiated or there might be a market value as opposed to a regulated value, Commissioner, I'm just wondering, to the extent this, and this is a question for Mr. Hodges too, but to the extent this is market-sensitive information or these would be negotiated on an individual basis, is there a way, would it be?
I'll withdraw. That's okay.
Well,
I will go a different direction, Mr. Cooper. Thank you very much. I don't want to mess that up, so I will withdraw that.
And Commissioner, we'd be happy to supplement it in it after, we have some follow-up information provided to the Commission. I just wanted to raise that as an issue, if it is.
No, it's not. I can go a different direction. Thank you for that, bringing up that point. Mr. Hodges, if Bridgestone were to want to purchase RECs from Dominion, that would be in addition to what they're already having to pay for the solar array, would it not?
It would be, but there would also be additional advantages for them, I do believe.
And can you, without getting into anything that might be proprietary or confidential, can you explain what those advantages might be?
Sure. So the advantage of the REC is that it would offset a portion of either their Scope 1 or Scope 2 emissions, and that would be to their advantage.
But they are still having to, if they choose to go with the solar array, they're still having to pay the cost of putting the solar array in as well as as for the REC.
Right, but keep in mind that in the interim period when the solar farm is not connected, and they would be reaping no advantages from the solar farm environmentally or otherwise, that they could purchase RECs from us and at least subsidize that advantage.
And has Dominion had discussions with Bridgestone about this advantage that Dominion's offering them?
I'm not aware of any discussions.
Okay. Thank you very much. I appreciate your testimony this morning.
Thank you, Commissioner Belzer. Any other questions, commissioners? Commissioner Irvin.
Could the witness provide a late filed exhibit if they wish to mark it confidential? That's fine. But I think we would like to know the answer to the question. and just to protect any proprietary concerns, we could mark it a confidential late file exhibit.
Okay, if we can get that, we mark it at number 11, hearing exhibit is number 11.
Thank you, sir.
Okay. Any other questions, commissioners? Okay, Mr. Cooper, any redirect?
No, Mr. Chairman, thank you.
Thank you. Okay, Mr. Hodges, thank you for being here. Thank you for your testimony, and you may step down.
And Mr. Chairman, just to clarify, Mr. Hodges is excused.
Mr. Hodges may be excused.
Thank you, Mr. Chairman.
Okay, Mr. Cooper. In fact, hang on, Mr. Cooper. Let's take a 10-minute break, and everybody stay on. Don't anybody drop off the call, but mute everything, and we'll be back in 10 minutes.
Many thanks, Mr. Chairman.
I'm not sure if we're back on or not.
You're on.
Okay, so we're just not on in the hearing room. Okay, welcome back, everyone. We're getting that straightened out, and we will. We are continuing. Mr. Cooper, it's your witness.
Thank you, Mr. Chairman. At this time, I'd like to call, Mr. Chairman, Dominion Energy calls Matthew J. Hammond to the stand.
Okay, now we're back on in the hearing room too. So, Mr. Hammond, as soon as we get you on there we go. All right. Forgot. Okay, I do have to have a roll call for commissioners every time we change up. So, Commissioner Belser.
Here.
Commissioner Howard.
Here.
Commissioner Irvin.
Here.
Commissioner Hamilton.
Here.
Okay, we're all here. And so, okay, now, Mr. Hammond, if you will please raise your right hand. And do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Okay, Mr. Cooper.
Thank you, Mr. Chairman. Mr. Hammond, please state your name for the record.
Matthew J. Hammond.
And by whom are you employed, in what capacity?
I'm employed by Dominion Energy South Carolina, and I'm manager of electric transmission support.
Have you prepared or caused to be prepared under your supervision rebuttal testimony of 19 pages that was previously filed publicly and confidentially with the Commission on July 14, 2020 in this docket?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No, I do not.
If I asked you the same questions here today, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, I move that the pre-filed rebuttal testimony of Matthew Hammond be admitted into the record as if given orally from the stand while maintaining the confidentiality of the portions of Mr. Hammond's rebuttal testimony that were pre-filed under seal in this docket.
Okay, we've got a couple of questions. We've got just listed the exhibits being confidential. Is there?
Mr. Chairman, you're correct.
Okay.
Would you like for me to, I can remove?
Well, we'll just enter, I'll just say Mr. Hammond's pre-filed direct testimony, pre-filed rebuttal testimony will be entered into the record as though given orally from the stand, and then we can move to exhibits.
Thank you, Mr. Chairman.
Okay, so you move the exhibits.
Okay.
And is the next, okay. So we've got confidential hearing exhibits, MJH 1 through 4. They're all confidential, and they will be entered as hearing exhibit number 12. All right, I think we've got everything in, so Mr. Cooper.
Thank you, Mr. Chairman. Mr. Hammond, have you prepared a summary of your rebuttal testimony?
Yes, I have.
Would you please deliver it at this time?
Yes, thank you. Good morning, Chairman Randall and members of the Public Service Commission of South Carolina. My name is Matthew J. Hammond. I provided rebuttal testimony in this docket on July 14, 2020, and I respectfully request to provide the Commission with this summary at this time. Dominion Energy is tasked with implementing the Commission-approved South Carolina Generator Interconnection Procedures, Forms, and Agreements, known as the South Carolina Standard, on a daily basis. I participated extensively in the development of the South Carolina Standard and am very familiar with it. I have been directly involved with every interconnection request Dominion Energy has received under the South Carolina Standard for projects greater than 20 kW. It is with this experience that I can state unequivocally that the South Carolina Standard applies to the generating facility that Bridgestone seeks to operate. Indeed, the generating facility will interconnect and operate in parallel with the Dominion Energy system, which means that Dominion Energy is required to process the generating facility's interconnection request in accordance with the South Carolina Standard
as adopted by this commission. In my third rebuttal, I address witness McGavran's claims that Dominion Energy's argument that the generating facility could influence the Dominion Energy system is strictly an academic argument unfounded by any real-world evidence. Witness McGavran's novel requirement of real-world evidence is not the standard for determining if the South Carolina standard applies. It is actually in direct conflict with the study and review process under the South Carolina standard. Dominion Energy cannot simply allow every generator to interconnect, operate in parallel, obtain the real-world evidence of such generators' influence on the Dominion Energy system, and then decide if the project should be processed, including studied under the South Carolina standard. This process must necessarily take place prior to the generating facility's operation on the Dominion Energy system, and Dominion Energy is unable to use real-world conditions from other parts of the Dominion Energy system to satisfy the study and review requirements of the South Carolina standard. Essentially, witness McGavran is sidestepping the initial question of whether the generating facility operates in parallel and should therefore be subject to the Commission's rules. By sidestepping this threshold question, witness McGavran jumps to what the results of any potential study under the South Carolina standard might conclude. However, this study and review process is the only way Dominion Energy can identify and address any potential reliability and safety problems before those issues cause serious harm to the Dominion Energy system, the Bridgestone system, or other customers in the real world. Likewise, the South Carolina standard does not permit Dominion Energy to allow the generating facility to jump the line and be studied and reviewed ahead of other projects that have waited patiently in the state interconnection queue simply because Bridgestone has already constructed the generating facility. With respect to witness McGavran, the final item I address is whether Bridgestone should be afforded special treatment since its generating facility has been constructed. To date, Bridgestone has ignored Dominion Energy, the Office of Regulatory Staff, and the rules of the state, but Dominion Energy cannot ignore the South Carolina standard, the Commission's jurisdiction, or the retail sales contract simply because Bridgestone completed construction of the generating facility without even having an interconnection agreement. This is not a concept recognized anywhere in the South Carolina standard. If it were, then developers would race to complete construction as fast as possible to cement their queue position at the front of the line. Such an approach is simply not contemplated by the South Carolina standard. When the South Carolina standard is followed, developers can make informed, knowledgeable, and market-based decisions about the renewable energy market in South Carolina. I then address witness Cannon's claim that Dominion Energy stymied Bridgestone's initial interconnection application in 2017. Bridgestone's 2017 interconnection request was intended for the Dominion Energy Bill Credit Agreement Buy-All Sell-All, or BCA program. The BCA program was suspended indefinitely on April 27, 2017 by the Commission in Order Number 2017-246. As a direct result of Bridgestone's inactivity, Dominion Energy was forced to remove the request from the queue in accordance with the South Carolina standard. Dominion Energy processed the Bridgestone request appropriately. Please note that the 2017 request was fundamentally different from and has no direct influence on the request at issue today. I next address witness Cannon's assertion that Dominion Energy gave Bridgestone the green light to construct the generating facility. I want to be clear on this point because it is a strange, consequential accusation. Neither Dominion Energy's policy nor the South Carolina standard places Dominion Energy in the position of telling developers when to begin construction on their projects. As Dominion Energy made clear in correspondence submitted in this docket on February 21, 2020, and as I will make clear now, Dominion Energy never told Bridgestone to begin construction on the generating facility. And Bridgestone began construction unilaterally with the knowledge that Dominion Energy had neither studied nor approved the operation of the facility. I also respond to witness Cannon's claim that Bridgestone's generating plant is not subject to the South Carolina standard because it is strictly for self-consumption and it will fully protect Dominion Energy's equipment and facilities. The South Carolina standard provides no exemption from regulation so long as the facility is for self-consumption or they fully protect the utilities, equipment, and facilities. Again, this is yet another distinction by Bridgestone in the hope to operate outside of any commission-approved guideline, principle, or regulation, and to send the generating facility straight into operation without any review. Finally, I respond to witness Cannon's claim that Bridgestone has met every requirement imposed by Dominion Energy. First, these are requirements imposed by this commission. Second, it is hard to imagine how this statement could be made when Bridgestone refuses to even acknowledge something so preliminary and fundamental as the processing of its interconnection request pursuant to the South Carolina standard. Bridgestone has not even acknowledged it is subject to the South Carolina standard, much less negotiated or executed an interconnection agreement for the generating facility. So I am at a loss when I read witness Cannon's claim that Bridgestone has met every requirement. In short, Bridgestone testimony evidences a fundamental misunderstanding of the South Carolina standard and why it applies to the generating facility. It applies because the generating facility will interconnect and operate in parallel with the energy system. This concludes my summary of my rebuttal testimony.
Thank you, Mr. Hammond. Mr. Chairman, Mr. Hammond is available for cross-examination by other parties and questioning by the commission.
Thank you. Okay, for cross-examination, Ms. Lee?
No questions here. Thank you, Mr. Chairman.
Thank you. Mr. Knowles?
No questions. Thank you, Mr. Chairman.
Okay, thank you. Mr. Flett?
Yes, sir, Mr. Chairman, if I may. Mr. Hammond, you testify on page 7 of your rebuttal, lines 13 through 17, as follows.
If you would just give me 1 second to catch up with you, please.
Yes, sir.
All right, I believe you said page 7?
Page 7, lines 13 through 17.
Okay, I'm with you.
Is it true that you testify as follows? Additionally, if the South Carolina standard is deemed inapplicable to the generating facility, DESC would have no oversight if Beto later increased its generating capacity, either by expanding the generating facility or by adding another generator without notice to DESC, the commission, or any other regulatory body. Have I read that correctly?
Yes, sir, you did.
And isn't it true, Mr. Hammond, that Dominion and Bridgestone's responsibilities and obligations to each other are governed by contracts approved by this commission?
That is my understanding, but I think Bridgestone has sought, the waiver that Bridgestone has sought with the commission is to interconnect the facility immediately, not subject to any scrutiny or oversight by the commission.
Well, Mr. Hammonds, were you in attendance yesterday when Ms. Courtney Cannon testified?
I was.
And do you recall Commissioner Howard's question to Ms. Cannon, which was, and I'll paraphrase, is Bridgestone prepared to permit Dominion to do a safety and security check to their solar array? You heard that question, didn't you, sir?
I think I heard that question.
And you heard Ms. Cannon respond without hesitation and without equivocation that by all means Bridgestone would permit Dominion to do a security and safety check. You recall that, don't you, sir?
I don't dispute that, no, sir.
And you understand that the party's contract is subject to the jurisdiction of this commission, don't you, sir?
Yes, I do.
And you understand that if Dominion has a problem with Bridgestone, which the parties cannot resolve on their own, Dominion has the right to do a couple of things. First of all, it can terminate service to the Bridgestone facility, can't it, sir?
That would be an extraordinary step, but I guess that's possible.
Yes, sir. Dominion has all the leverage in this matter, doesn't it, sir?
Mr. Chairman, this is Ashley Cooper. Again, Mr. Elliott's asking for the witnesses to provide legal conclusions on their contractual rights, legal remedies, the ability to cancel the contract. I'm happy for him to answer questions about the interconnection procedure, providing it, but not provide legal conclusions. So I object.
Okay.
Mr. Chairman, I'm not asking for a legal.
We're going to overrule that objection, so continue.
Thanks, sir. And Mr. Hammond, do you understand that since the commission has exercised jurisdiction over the contract between Dominion and Bridgestone, that if Dominion has a problem with Bridgestone's conduct under the contract, it might bring an action in this commission seeking the commission's assistance and a remedy from the commission with respect to Bridgestone's violation of a term of the contract. You understand that, don't you, sir?
Mr. Elliott, that sounds reasonable. I don't pretend to be an expert on the Bridgestone contract. I'm not even sure I've ever seen the contract. So I really would prefer not to testify on that contract.
And you understand, Mr. Hammonds, that if Dominion has the right under the party's contract to seek assistance from this commission to remedy a problem it has with Bridgestone, that Bridgestone has the same right to seek the assistance of this commission to remedy a problem that Bridgestone believes it has with Dominion. You would agree with that, sir?
Mr. Chairman, this is actually Cooper, counsel for Dominion. Again, I object. The witness just testified they lack sufficient understanding of the contract to testify on the contract.
We're going to sustain that.
All right, and you were here a moment ago when Mr. Furtick testified, were you not?
Yes, sir, I was.
And you heard Mr. Furtick testify that under the terms of the party's contract, Bridgestone must give Dominion adequate notice of any changes to its to the generation at the Bridgestone plant. Isn't that true?
I don't dispute that, sir.
Now, as I understand your testimony, you have been involved with the SC GIP, I guess going back to the Commission Order 2016-191. Is that a correct statement?
Yes, sir.
All right, and so as a consequence, and you testified that you were involved in Bridgestone's first effort at solar development. Isn't that true? I processed their interconnection request and communicated with Bridgestone on that request. Yes, sir, that's true. All right, sir. And initially, Bridgestone tried to take advantage of a Dominion program called the Buy All, Sell All program. Am I correct?
It is. I would add that that's not a component of the generation interconnection procedures. That's a separate program administered by our renewables group. So while I am familiar with it, it is not something that falls under my purview.
Very fine, but you understand, because you've been involved in this going all the way back to order number 2016-191, that Buy All, Sell All program was subject to the SC GIP, sir?
There were requirements for qualifying for that program that included a valid, if I understand or remember correctly, it included having a valid interconnection agreement and meeting all financial terms due to Dominion Energy prior to being able to be admitted into that Buy All, Sell All program.
And the Buy All, Sell All program was exactly what it says. Dominion, Bridgestone would generate electricity from a solar array, which was operated in parallel and interconnected to Dominion's distribution or transmission line, and Bridgestone would sell all of that electricity to Dominion. That was the way the program worked, correct?
Mr. Chairman, this is Ashley Cooper, again, counsel for Dominion Energy. I would object. The witness has a lack of foundation on the Buy All, Sell All program. As the witness testified, the Buy All, Sell All program is an energy purchase and sale program. It is not an interconnection agreement. The Buy All, Sell All program does not operate under the interconnection agreement, and so the witness lacks a foundation to testify on the Buy All, Sell All program and the details of that program.
Well, Mr. Chairman, this witness testified on pages 11 and 12 of his testimony all about the Buy All, Sell All program and Bridgestone's attempts to avail itself of it. And unless Mr. Cooper is prepared to withdraw all of this witness's testimony on the Buy All, Sell All program, I believe that he's subject to cross-examination.
He is. We're going to overrule the objection, and the witness can answer the question if he knows the answer.
Please go ahead and answer, Mr. Hammond.
Can you repeat the question?
Isn't it true, Mr. Hammond, that under the buy all, sell all program, Bridgestone would construct a solar array, operate it in parallel, interconnect it to Dominion's distribution line, operate it in parallel, and sell all of the output to Dominion? Isn't that true?
That's correct. The buy all, sell all program would be a direct connect to the Dominion Energy system, and it would sell all the output of that facility directly to Dominion Energy. It would not have had an impact on their consumption at their primary points of service.
Very fine. Thank you so much. Now, let me draw your attention, Mr. Hammond, if I may, to your involvement with Bridgestone in designing and constructing the solar array that we are here litigating today. May I?
I've had no involvement with Bridgestone on designing or constructing that facility, sir.
So let me ask you, are you Matthew J. Hammond?
I think we may be having a problem with semantics, sir. I have received and processed their interconnection request, but at no point have I participated in their design or construction of that facility.
All right, good. Thank you for that. Now, let me, by way of background, let me ask you several questions, if I may. Who is DJ Stone?
DJ Stone was an analyst at Dominion Energy at the time of the initial, the second request when we received it.
And you worked with Mr. Stone on whatever it is you did with this solar array, correct?
That's correct.
And you're familiar with the consultant Solar Alliance, are you not?
I'm aware that they submitted the initial paperwork. We had a lot of dialogue with them. I have not really had an extensive interaction with that organization.
Very fine. And so you will recall, will you not, that among the people you dealt with at Solar Alliance was John Hamilton. You recall that, don't you, sir?
Yes, sir.
And Mr. Hamilton had an associate named Abuleta. Do you recall that?
I'm sorry, I do not recall that. I don't doubt it to be true, but I don't recall it specifically.
And you wouldn't have been able to recall it from my pronunciation anyway, but thank you. And of course, you worked with Jess Ballantyne when he was still employed at SCANA, correct?
That's correct.
And Mr. Ballantyne was the large customer account rep for the Bridgestone plant until he retired. Isn't that true?
That's correct.
And just a little more background. Can you tell the commission who Stephen Scott Bell is?
Stephen Bell is an engineer that reported to me for, I'm not sure the exact time frame, a year or a year and a half, and he was also in the transmission support group at the time of the submission of the requested issue today.
So is it fair to say that Mr. Stone and you were working with SCANA in March of 2018?
Yes, that's correct.
And is it fair to say that however you would describe your duties and responsibilities, that you were in correspondence with Solar Alliance on behalf of Bridgestone? Isn't that true?
It is, in fact, true.
And isn't it true that at the time, March of 2018, you were dealing with Lee Schiffhauer, the Bridgestone engineer? Isn't that true?
It is. Lee and Mr. Freeman, Mr. Schiffhauer and Mr. Freeman were two of my primary contacts at Bridgestone during that time.
Now, in March of 2018, you were in discussions, you personally were in discussions with John Hamilton of Solar Alliance over the design, the specifications of the current solar arrays that we're litigating, correct?
Probably semantics again, sir. We would have received that interconnection request and worked with Bridgestone and Solar Alliance to make sure that request was complete and met all of the requirements of the standard to obtain a Q position. But we don't typically get involved in the design of the customer's facilities. They theoretically really should come to us with a fully designed project and submit that project for interconnection.
But you were happy to work with Bridgestone on this matter in March of 2018, were you not?
Oh, yes, sir. Yes, of course.
And then you had, in your conversations with Mr. Hamilton of Solar Alliance, you were informed that Bridgestone did not intend to sell power back to Dominion, were you not?
That's true, that we had conversations about their intent.
And isn't it true that you were informed that since Bridgestone's energy demand was significantly greater than the solar production, you could not expect solar-generated electricity to be sold back. Isn't that true?
Sale back implies a power purchase agreement, and I don't work on this power purchase agreement. It's just a matter of really originates in FERC policy. The power purchasing and the interconnection are required to be separate functions by the Federal Energy Regulatory Commission. We apply that to state jurisdictional projects as well. So from my perspective, it's really almost irrelevant that if they would have consumed all that power on site or if it had moved back up onto the grid. It's not really a decision in the interconnection process that we hone in on or focus on.
Thank you. Now let me ask my question again. You were informed of this fact on March 19, 2018, were you not, sir?
I can't confirm that date, but we had a lot of discussions with
Counsel for Dominion Energy. I understand that Mr. Elliott was seeking to lay a foundation. It appears, though, that he's laid a foundation, but is now questioning Mr. Hammond off of an email or email chain, and I don't know that he's provided Mr. Hammond with the email.
I've not provided Mr. Hammond with the email. All counsel and the commission have a copy of the email. And I'm happy to stipulate this into the record as the next hearing exhibit. Let Mr. Hammond have a copy of it, and we'll go through it. If that suits counsel, I would stipulate as an exhibit an email from Stephen Scott Bell, dated Friday, March 23, 2018 at 8:49 a.m. to John Hamilton and others into the record at this time as the next hearing exhibit.
Okay, so you're going to email that to well, we've got it here. Okay, so that will be.
Has it, and I emailed, my secretary a few moments ago emailed it to all counsel,
okay.
all parties.
We will enter it as hearing exhibit number 13.
Excellent, thank you so much. And so indulge me, Mr. Hammond, while we wait for very capable staff to place this email on the Elmo. And Madam Clerk, I would like to start from the bottom. It's a two-page document. I would like to start from the bottom of page 2 initially, and you will find in the lower half of that second page, MATT, M-A-T-T, and over the electronic signature of John Hamilton.
And Mr. Chairman, if I could, I just want to make sure. I don't know if the attorneys for Dominion have ever received a copy of this email. I guess we're going to put it up on the screen, but
it's up. But all parties got a copy.
But she was instructed about 5 minutes ago to email it to you.
Ms. Wessinger Hill's going to.
Mr. Chairman, I just received a copy, and on the notice on the email, it appears that all parties in the record actually received a copy, and I got it at 12:02 p.m.
Okay. And thank you, Mr. Chairman. Yes, I just got confirmation. We'd received it, but I just got confirmation it went through to the Dominion lawyers as well.
Yes.
Thank you very much.
You're welcome. It was from Miss Linda Kitchens, who's the legal assistant for Mr. Elliott.
Thank you. I sent it, just to be clear, I think it, I don't know if it was Ms. Wessinger Hill's suggestion or Ms. Boyd's. I had sent it to Ms. Dukes and Ms. Crocker earlier so that you would have copies, Mr. Commissioner.
We have that.
All right, Mr. Hammond, let's look at this email then. Thank you, Mr. Cooper, for your help on that. You will look at the bottom, it is from John Hamilton, Customer Service Manager, Solar Alliance. You see his name?
I do.
And of course, you recall corresponding with Mr. Hamilton, do you not?
I do, and I'm familiar with the correspondence around this reverse flow protection scheme.
Excellent. Thank you so much. Now, Mr. Hamilton writes, I called to follow up last week from our previous call and discuss where we are with the reverse flow protections. I've attached some specifications, but before we went into greater detail, I want to clarify how you needed us to respond. Have I read correctly?
Yes, sir.
And then Mr. Hamilton goes on to say, in summary, Bridgestone does not intend to sell power back. Further, since their demand is significantly greater than the solar production, this is not expected. You recall his informing you of that in this email of March 19, 2018, do you not, sir?
Sure.
And then he goes on to suggest some protections, and I'll read it rather than summarize it. For protection against reverse flow, we discussed two options on site last week. One or both may be employed. One, installing multi-lin 350 relay with reverse power protection to replace existing square D power logic. Two, installing L-gate control at the PV array, which could curtail power output at the inverter and or transformer level based on plant energy and consumption thresholds. Have I read 1 and 2 correctly?
Yes, sir.
And you have been to this site, have you not?
I've visited Bridgestone once, the meeting that we had with ORS. That's the only time I've been to the Bridgestone facility.
All right. And then again, Mr. Hamilton attaches some product specifics and says, writes, we would again like to discuss both SCE&G minimum requirements and what we need to provide to move forward. Do you see that?
I do.
All right. And you received this email on or about March 19th, did you not?
Yes, I can't see the date, and I don't have that memorized, but I don't dispute that.
Well, I don't want to take advantage. Would you scroll up a little bit, Madam Clerk?
Perfect. Yes, I see the date,
right.
and I am here with this communication, the communications around this.
All right, very fine. Thank you. Now, Madam Clerk, if you will go to page 1, and Mr. Hammond's response starts about 2/3 of the way down the page. All right. Do you see your response there? It says from Hammond, Matthew J. Matt, sent Thursday, March 22, 2018. Do you see that?
Yes, sir.
And you sent that back to Mr. Hamilton, who was with Solar Alliance and was Bridgestone's consultant, correct?
That's correct.
And among others, you sent it to Mr. Schiffpower with Bridgestone. Is that correct?
Yes, that's correct.
And you copied Mr. Ballantyne because he was the large customer service rep for the client, correct?
Correct.
And there are others that you copied, but I point those out. Now, I'm going to read your response, and I will ask you if I've read it correctly. John, I've spoken with our relay group. Option 1 is a typical solution that we are familiar with. They indicated option 2 could work, but definitely preferred option 1. One other key consideration we must investigate is accommodating the 115 kV auto switching scheme. We need to ensure coordination between that scheme and the reverse flow and voltage protections for the solar project. If we are definitely headed down this path, we'll start working on an IA and a refund of the $500 fast-track processing fee. Let me know your thoughts for the next steps. Have I correctly read your response to Mr. Hamilton?
Yes, sir.
And when you reference option 1, you're referring to the installation of the multi-lin 350 relay with reverse power protection to replace the existing square D power logic. I'm assuming that's the existing relay in the plan. Is that correct?
I would also probably assume it's an existing relay in the plant, but yeah, option 1 is referring to the 2 options that he provided initially.
All right, not sure I followed that. When you refer to option 1, you say option 1 is a typical solution you're familiar with, and option 1 on Mr. Hamilton's email is installing the multi-lin 350 relay. Am I reading that correct?
Yes, sir, but you added a sentence at the end that you were assuming it was the existing relays, and I don't have a lot of knowledge about the Bridgestone equipment, so that was the piece that I wasn't 100% sure of. The option was definitely referring to this option 1 right here.
I see what you're saying. I didn't mean to confuse it. I thought you could clarify it, and it doesn't matter what the square D power logic is, so forgive my...
Yes, sir. And I apologize for being nitpicky, but I've sworn to tell the truth, and I only want to speak to what I know.
All right, and then the relay group indicated that option 2 could work, but they preferred option 1, meaning they preferred installing the multi-lin 350 relay, correct?
That's correct.
And you understand, do you not, whether it's based on your personal knowledge or your thorough review of the matters in this docket, that Bridgestone has installed the multi-lin 350 relay. You understand that to be the case, don't you?
I understand it from Bridgestone's statements and testimony.
And you understand that the multi-lin 350 relay also had an opportunity to prove itself in a June 4, 2020 fault along Dominion's distribution lines caused by Mylar balloons. You understand that, don't you?
Only in what I've seen in the testimony. I have no direct knowledge of that event.
All right, and then you go on to see if we're definitely heading down this path, we'll start working on an interconnection agreement and refund the $500 fast-track processing fee. Do you see that language?
I do.
As I understand this, an interconnection agreement would be required under the SC GIP once the generator and the interconnection is approved. Is that correct?
And I would be required at the end of any interconnection process. And Mr. Elliott, it might be helpful if I give a little additional background at this point. When Bridgestone submitted its request, the request was a little different in that Bridgestone was a large customer that wasn't applying for service under the fast track process. They actually submitted under the fast track process. They simply weren't eligible for submission under the fast track process. So we spent a good bit of time with Bridgestone and internally trying to determine if the standard applied, given that the submittal was a bit unique in that regard, that it was a large customer applying for interconnection that didn't qualify for fast track treatment. We ultimately determined that the South Carolina standard did apply and notified Bridgestone as such, and have been working along this path ever since. So there was an initial period where we were trying to confirm that the Bridgestone project needed to submit under the standard. We ultimately decided that it did, and that's where we've been moving.
But on Thursday, March 22, 2018, you thought that Bridgestone had met all your concerns and were prepared to start working on an interconnection agreement and fund the $500 that you took for a program that now you say they weren't eligible for. Is that your testimony?
Mr. Chairman.
Not exactly, sir.
This is Ashley Cooper, counsel for Dominion Energy. Asked and answered. The witness has answered this. He's provided even greater context. I think we can move on.
Okay, we're going to sustain that. Let's move on.
Thank you, Mr. Chairman. Now, in your email, you inform Mr. Hamilton that we need to ensure coordination between that scheme and the reverse flow and voltage. Let me back up. Excuse me. You wrote one other key consideration we must investigate is accommodating the 115 kV auto switching scheme. We need to ensure coordination between that scheme and the reverse flow and voltage protections for the solar project. Recall testifying, telling them that?
I do.
And you were here for Mr. Furtick's testimony, were you not?
I was.
Mr. Furtick testified that that one of the key considerations remaining for this solar array was that Dominion needed to investigate accommodating the 115 kV auto switching scheme. Recall his testimony?
I do, yeah.
And so, isn't it true, Mr. Hammond, that Dominion has known about this key consideration since at least March 22 of 2018?
I would, but I also would say that we would normally handle this type of work either in the study process or in the contracting phase. And if we don't do it in either of those two steps, it would be after contracting and we've identified all of our interconnection requirements in our interconnection agreement, and then shortly before the interconnection of the facility to the system. So yeah, I'm aware that we identified that early on. That I think other witnesses have testified this. That's actually a scheme that is in place for Bridgestone's benefit, so that they are more likely to remain in line during certain contingencies. It's in our best interest, and particularly in their best interest, that that scheme be properly coordinated and allowed to function after the facility is interconnected.
Now, I'd like to ask you, Mr. Hammond, if at Dominion Energy, you operate under any budgetary constraints?
We do have annual budgets.
Mr. Chairman, this is Ashley Cooper, counsel for Dominion. I object to the form of that. I mean, if there's a question, any budgetary constraints, I don't know what the witness is supposed to answer with that.
And Mr. Chairman, I appreciate Mr. Ashley Cooper coaching his witness. It's a pretty simple question, Your Honor.
Mr. Chairman, I'm not
I don't think he's finished the question yet, has he?
I will repeat it. Isn't it true, Mr. Hammond, do you at Dominion and your department operate under a budget?
We do operate under a budget. Our budget rolls up to our transmission services organization, so I personally have very little oversight or control over my precise budget.
And of course, you understand, and it's been your experience, that sometimes your department is unable to perform certain functions because of budget constraints, correct?
No, sir. I've not been constrained by the budget in any of my primary functions, or any function at all, actually. I would not agree with that statement.
Well, it'd be fair to say that as a monopoly utility, Dominion doesn't have any budgetary concerns.
Again, Mr.
No, sir,
Chairman,
I wouldn't agree with that either.
Again, Mr. Chairman, this is Ashley Cooper. Objection to this line of question. Right? What is the question? Any budgetary constraints at all for the entire utility? Is that what he's asking this witness about?
Move on, Mr. Chairman. Now, isn't it true, Mr. Hammond?
Thank you.
That you testify, it is unclear to me precisely why Beto believes that DESC gave or would give under any circumstance Beto or any other generator the green light to begin construction. Certainly, that was not the case here. Did you testify to that, sir?
I would appreciate it if you could point me to the page and lines of that testimony.
Well, I'm sorry, you testified to it in your summary, but look at page 13, lines 9 through 12, please.
Okay, I'm there. Thank you.
I'll reread it and follow along, please. Isn't it true that you testified that, quote, "It is unclear to me precisely why Beto believes the desk gave or would give under any circumstance Beto or any other generator the, quote, green light, unquote, to begin construction. Certainly that was not the case here." Is that your testimony?
Yes, it is. Thank you for allowing me the time to catch up with you.
Absolutely. Now, I draw your attention to hearing exhibit number 9. It is an email from Daniel F. Cassis to Derek Freeman. Do you have a copy of that?
I don't have a copy of that.
All right, Madam Clerk, it's hearing exhibit number 9. Just came in a moment ago.
We're getting that taken care of. Okay, has that got it where everybody can see what we need to?
Well, I'd like to start with the bottom email, the one from Derek Freeman, if I may. Just scroll it down. Can you see that, Mr. Hammond?
I can see that, yes.
Thank you. I'll draw your attention to Mr. Freeman's email first. Good morning, Danny. Mr. Cassis goes by Danny, does he not?
He does commonly go by Danny.
Thank you. Mr. Freeman writes, "We at Bridgestone are quickly coming up on end-of-year time limits where we need to make financial decisions for capital spending because we budget capital for upcoming years. The project is scheduled to be completed in 2018, but rolls over. If the project is scheduled to be completed in 2018, but rolls over into 2019, then projects will have to be canceled or delayed to make room for the 2018 carryover. If we know now in time and can move a 2019 project up, then we can offset the carryover by doing the 2019 scheduled project early. The larger the project, actual dollars, to be carried over, then the sooner we need to know in order to have time to offset it. Is there any movement on the decision to let Bridgestone continue with the installation but not activate the solar project? We have several $100,000 already spent, and we still have several $100,000 still budgeted to spend in 2018. Have I read Mr. Freeman's testimony correctly?
I think that's an email, but you've read the email correctly.
Yeah, thank you. Now, would you agree with me that that Bridgestone had budgetary concerns with respect to the construction of this solar array?
Based on that email, I think we can agree to that.
And of course, you are aware that you were aware as a result of your conversations with Mr. Hamilton that Bridgestone had already had some cost and capital expense invested in the project as of August of 2018, correct?
I don't recall there being capital costs at that time, but I know that they would at least have had the time and expense of creating an interconnection package or single line diagrams, things of that nature.
All right. So Mr. Cassis's response was very careful. He responds, "I am still working to find a way to address the interconnection issue." Now, I would like to stop there. Mr. Cassis is the vice president in charge of customer service, I think. That's a fair statement. And he would have a great concern about making sure that his customer, Bridgestone, their needs were met as best he could, correct?
We all have great concerns about the needs of our customers.
Thank you. And Mr. Cassis goes on to say, however, as we both noted, finding a workable solution is complicated because any solution must not discriminate against other parties that want to interconnect to our system. And that sentence from Mr. Cassis is consistent with your testimony, is it not?
It's consistent with my testimony, and I think we've seen the industry echo that, and that's probably driven the fact why Mr. Cassis added that in his email. The state interconnection standard was developed in an open process, the Office of Regulatory Staff. We had at least 3 meetings and maybe 4 meetings. Of course, us and the two Duke utilities were involved. Central Electric Power Cooperative was involved. The South Carolina Solar Business Alliance was involved. The Alliance for Solar Choice was involved. There were several solar developers represented. The national entity, IREC, was involved. And we all crafted that interconnection standard. And Mr. Cassis is responding to the knowledge that we gained from that process and our work to understand that one party can't be discriminated against, or one class of customer can't be discriminated against over others in conflict with the South Carolina standard.
All right, and then Mr. Cassis goes on to conclude his email saying as follows: Bridgestone has the right to build the asset, but the interconnection of the asset is prohibited until we reach a resolution that our regulators will approve and that will not discriminate against solar projects. Have I read that correctly?
You have read it correctly, and I agree wholeheartedly with Mr. Cassis' statement. We can't control the spending of any of our customers. They can spend their capital in any way that they choose. But we are responsible for controlling the interconnection of facilities to our system. So I think Mr. Cassis' statement is dead on, and we wouldn't pretend to control Bridgestone, but we do have very real regulatory obligations with regard to interconnection of facilities to our system.
Thank you very much. Now, Mr. Chairman, I would like to cross-examine this witness concerning his confidential exhibits.
Okay. Hang on one second. Okay, we need to pause for a moment while we get out of the live stream. And I'll let you know when it's time to start again.
Thank you.
Welcome back, everyone. We are now back in open session after dealing with some confidential information. And I think it's time for commissioner questions. So commissioners, are there any questions for Mr. Hammond? Commissioner Belzer.
Good afternoon, Mr. Hammond. Thank you for your testimony today.
Hello, thank you, Commissioner.
If you were listening earlier, I believe I asked Mr. Furtick a question and he punted to you. So I'm going to ask you, how long does it take Dominion to perform the studies required under the South Carolina GIP?
So I'm going to make the assumption, that Mr. Furtick made that you're referring to the study process. Remember, there are 3 processes in the state interconnection standard: the 20 kW and less inverter-based project process. That's for the small rooftop programs. And then the fast track process is for projects that are connecting to our distribution system. There's more criteria than that, but that's kind of the key one for us today. And then the third process is the study process. Under normal circumstances, I'd say it probably takes around a year, maybe even longer, to get through that process. I would point out, and I think it's important to point out, that the interconnection customers can control that process almost as much as we can. And what I mean specifically is that there's a number of back and forths in the interconnection process. If we issue a report, then you frequently have to go to the next study, and a customer will get, say, 30 days to return that study. So a customer that's in a hurry could return that study right away and take only 1 day. We tend to find that customers wait till the last minute on average. In fact, with almost that exception, they tend to wait till the last minute. So of that year, year and a half, depending on the way they move forward, a good bit of that time is actually due to the customer and their deliverables.
Okay, so a year to a year and a half, but the customer's holding things up is what you're telling me.
I wouldn't say holding it up necessarily. They do. I mean, they have a certain amount of time under the standard. That's their right. We absolutely respect that right. We do enforce that right, though. So if the standard says they have 10 business days to return an agreement, and they return it on the 10th business day, then I consider them to be in good standing. I don't view that negatively at all. But if they don't return it by the 10th business day, then I feel that Dominion Energy South Carolina is forced to withdraw that project from the queue. So I didn't mean it as a negative that they take time, so much as just an acknowledgement that interconnection customers can drive quite a bit of the timeline.
Well, if y'all are withdrawing someone from the queue, why aren't the others bumping up some or moving up?
We have had yes, ma'am, that's a fair question. We have had a number of projects withdraw from the queue, and projects are moving up. I guess to clarify, the timing I described, it reflects our responsiveness prior to the rush of projects. Some people call them speculative projects. I know that term isn't necessarily viewed positively, so I won't necessarily call all these projects as speculative, but we do have a large number of projects that are in queue that don't have any sort of offtake agreement, and those projects have overloaded our ability to study and meet the system impact study timelines prescribed in the state interconnection standard. I think witness Xanthakis ran through this in some detail, but when you get to a certain level of penetration, and we're there, we're beyond there actually, it's common for major upgrades to be associated with additional generation. And the state interconnection standard requires us to study a project with all prior queued projects in that study. And so in order for those projects to be studied, if there's a project ahead of it that's still in a valid queue position, but it's got a major upgrade associated with it, we also have to plug that major upgrade into our studies. And so then if that project were to withdraw from the queue, now the studies of all the subsequent projects are no longer valid because the project's not there and the upgrades that they triggered aren't in those studies. So, and we need to recognize the penetration issue because it's a very, very important and a very key issue that's driving the complication that our planning engineers are dealing with. If one of our planners were to start a new system impact study today, it would have approximately 1,800 megawatts of solar in it. Our minimum daylight load is approximately 2,200 megawatts. So that leaves us with 400 megawatts of our own traditional resource to be online to test that project accurately. As a result, we really can't study that project under low load scenarios. And actually, we really aren't able to study this project under mid-load scenarios at this point. So we're only studying our higher load scenarios for current interconnection studies. And I may have jumped ahead a little too far on that one. When we study, make a system impact study, we have to balance the system. So supply has to equal load. In order to add the new generator, we have to take off a generator. That's the only way to accurately perform those studies. We have to have so much generation online to meet essential reliability services. So the complications with balancing are also greatly impeding the ability to study a current project.
Well, let me ask you, with the situation we have here, where where Bridgestone is seeking to utilize 100% of what the solar project produces, how will that impact those studies? It's not going out on Dominion's system, is it not?
So the energy from the solar array, we would not study it as going out on the system, but we would see a change case in adding that generator. And what I mean specifically is the introduction of that generator will alter the power flows on our transmission system. Altering those power flows could have consequences up or downstream. And let me be clear, I'm not suggesting that the 2 megawatts at Beto would cause a problem. I don't know that. We haven't performed the studies. But if Beto were to install 30 megawatts, which they could potentially do if they get the waiver they sought in this case, that could have very real implications for the power flows on our system. Not that the generator output is flowing on our system, but that the impact of that generation impacts the flows on our system. And that also goes back to witness Santhakis' comments that the reverse flow relays only protect against one element of power flow, and that is real kW, real power. You have VARs, you have harmonics, fault current. There are many other aspects of generation interconnection studies that reverse flow relays really wouldn't have an impact on.
Well, there's been no allegation that Bridgestone may try to put 30 megawatts on the system where we are now. And I understand what you're saying if they get the waiver, but if a waiver were granted, could not the waiver be tailored so that they would have to talk with Dominion and work with Dominion before they enlarge the system? And another thing is, wouldn't service agreement that Dominion and Bridgestone have, Bridgestone would have to notify Dominion under the service contract, would they not?
It's a great question, and I think it's a really important question for the case in front of us today. For what Bridgestone asked for, it's very concerning for Dominion Energy South Carolina, because they asked, if I understand, I'm not a lawyer, but if I understand what they asked for, it would be to not be subject to the state interconnection standard. That's a very challenging thing for me to feel comfortable with as someone who is responsible for the safety and reliability of our system. We need to know what's connected to our system. The Bridgestone 2 megawatts would be connected. If the commission were to consider a waiver, it would, and if I had the ability to offer my opinion on that, I would suggest that the waiver shouldn't be to the South Carolina standard, but only to the queue requirement. Move them to the front of the line, exempt them of one of our study requirements, which is to put everything in the queue ahead of them in that study, and we can study that project. In fact, we've committed, if Bridgestone were to receive a waiver of this nature, we've committed in correspondences from our lawyers to their lawyers to conduct that review in an expedited fashion. There would be some back and forth. There would be some handling of contracts. There would be an interconnection agreement that would need to be written. So if you were to make that order, we wouldn't interconnect them tomorrow or next week, but it would happen in fairly short order.
Thank you very much. Appreciate your testimony today.
Mr. Chairman, Commissioner Hamilton.
Commissioner Hamilton.
Thank you, Mr. Chairman.
Yes, sir.
Happy to have you with us today, Mr. Hammond. Can you hear me?
Yes, sir. Thank you.
Okay, good. Mr. Hammond, in your opinion, would every standby generator at every hospital, water plant, sewer plant, bank, or data center be subject to the South Carolina interconnection procedures? If not, give me why not or why it could be.
Yes, sir. That's a great question. Thank you. That is something that was added in some of the other witnesses' testimony, the Bridgestone witnesses' testimony that was incorrect. The interconnection standard, as I understand it, and it's straight out of the first sentence of the applicability section, is for generators that are going to interconnect to and operate in parallel with the utility system. That parallel operation is key here, and the Bridgestone facility absolutely operates in parallel. A standby generator that you've asked about, a hospital, a grocery store, those don't operate in parallel with the system. Those are intended to operate when the utility system goes away. So we would have an open disconnect between our system and that hospital or that grocery store, and that generator would supply their needs while our system was unavailable. In that scenario, that generator literally has no tie and no ability to influence our system. That is not the case for a solar resource that's going to be online and operating anywhere from 10 to 12 hours a day, day in and day out. Those two things have two very different risk profiles, and I believe that the interconnection standard recognizes that by only requiring us to apply the standard to parallel operating generators.
Thank you very much for that information. Let me ask you one other thing. Where does Bridgestone stand in the queue today?
Yes, sir. Bridgestone's queue position is number 375. I don't know exactly which position we're studying today. There is still a meaningful number of projects ahead of Bridgestone, including some FERC jurisdictional projects. If I may, Commissioner, we do think that we are required by our state and federal statutes to slate projects in a serial queue order regardless of the project they're submitted under. And we just have a handful of FERC projects that are coming up for study next.
They've been in there since 2017 in the queue. That's when it started the project.
They submitted interconnection request before the Bridgestone one. Yes, sir. So either in 2017 or in 2018 before the Bridgestone submittal.
And they're still 375.
Yes, sir. A project's queue position doesn't actually change as it moves through the interconnection process. So Bridgestone will retain the 375 queue position even after it's received an interconnection agreement.
Okay. I'm looking at the queue incorrectly. Where do they stand as to timeline? Who's in front of them before they could be connected?
So if you have the queue open, and we do publish it on an external website every month, Bridgestone's queue position is 375. Any project ahead of them by like 374, for example, 373, all those projects would be ahead of Bridgestone, and we would be required to study them under the standard before we would study the Bridgestone project.
Mr. Chairman, I'd like to get a late filed exhibit on exactly, so we can understand exactly where they are.
Okay, we'll have that as number 14. Hearing exhibit number 14.
Thank you, Mr. Hammond, for your testimony.
Thank you, sir.
Okay, thank you, Commissioner Hamilton. Any other commissioner questions?
Mr. Chairman.
Commissioner Irvin.
Mr. Hammond, are you familiar with what the stakeholders are doing in North Carolina to try to reform the queue process to cut down on these delays?
Yes, sir. I've not participated in those dockets as we don't have any business in North Carolina. The North Carolina stakeholders are seeking to modify the North Carolina standard based on a FERC-approved standard by the Public Service of Colorado. And it's kind of fundamentally different, but I am familiar with that process.
All right. I asked Mr. Furtick earlier today if he would look into it and see if we can apply some of those principles in South Carolina. You wouldn't have any problem with that, would you? The stakeholders were involved? No,
sir. Actually, we've been prepared to engage in the interconnection docket. I believe it's 2019326E. We've been prepared to engage in that docket since it was created and seek the opportunity to do so.
Great. That's the only question I had. Thank you, Mr. Chairman.
Thank you. Commissioners, any other questions? Okay. Mr. Cooper, any redirect?
Mr. Chairman, I'll be brief.
Wait a minute. Let's just hold on to that if we're going to do, because we've got a commission meeting at 2 o'clock. We've got to give everybody a chance to have lunch and to breathe for a second and get regrouped for the commission meeting. So we're going to break right now. We'll recess. We'll come back. The commission meeting will be at 2 o'clock, and this meeting will start. Ms. Boyd is getting on the microphone.
Yes, sir. Mr. Chairman, if you don't mind, would you please ask Commissioners Irvin and Howard to remain in WebEx? We're going to include them in the meeting with their positions where they are right now via WebEx.
Okay.
Okay.
Okay. Commissioners Howard and Irvin, did y'all hear that? Okay. Good.
Got it.
Okay. So we will come back for a commission meeting at 2. And then it will probably be somewhere around 2:30 or a little after, but we'll have to make sure we get everybody back on. And so if everybody will just be watching, we'll do this the best way we can. 2:30 should be fine, according to Ms. Wessinger Hill. So, okay, so we will recess right now, and we'll be back this afternoon. Thank you.